So let's go into joint ownership for just a minute.
Yeah, joint ownership. There's several types that are set up in your textbook of joint ownership, but I'm going to talk about the ones that are typically what we see. And joint ownership is just exactly what you think it would be, which is I own something with somebody else. The most common types are joint tenant with right of survivorship. So like for those who are in Texas, typically we'll see that on people's bank accounts. A lot of times you'll see the acronym or the initials there, JTWROS, which is the joint tenant with right of survivorship. The other common one is tenants in common, which sometimes you'll see noted as TIC. A lot of times you'll see that on investment accounts. A lot of people, when they own real estate, they'll own real estate as tenants in common, so there's joint ownership. And so those are probably the two most common forms of joint ownership. The joint tenant with right of survivorship, kind of the key difference between those two is with joint tenant with right of survivorship, you jointly own it, but there is an automatic passage at death to whoever the survivor of the account is. So if you and I owned an account together and we owned it as joint tenant with right of survivorship and I passed away, the account would be yours, completely yours. Tenant in common works a little bit differently in that if you and I, like I said, typically own real estate together, if you and I own real estate as tenants in common and I passed away, you own 50% of the property, an undivided 50% interest in the property. My estate owns an undivided 50% interest of the property. You don't inherit or get the entire piece of property because we were just tenants in common. So that's kind of the two difference. And that, for the most part, if you're in Texas, those are the two that you're going to see, the two types of joint ownership.
So I guess the next thing I'd like to talk to you about are the pros and cons of joint tenant with rights of survivorship.
Yeah, so again, joint tenant with right of survivorship is when you jointly own an account, but when whoever one of the account owners dies, then the remaining account owners, the surviving account owners inherit or become the owner of that account, the sole owners of that account. So the positive thing about this is, like, if you and I own a bank account together and I pass away and it goes to you, that transfer occurs outside of probate. So you don't have to probate anything in order to succeed to the account as the survivor. So that's a real positive. The other real positive is that most of the time this is set up at the time that the account is established, and so to some extent it's a sign it and forget about it type of estate plan.
Right.
So that tends to be something that clients like. The con is that anytime that you have kind of a joint ownership thing, especially joint tenant with right of survivorship account, both tenants have the right to use the property that's inside that account. And so we've seen many examples where, a mom or a parent will be on an account and they'll put their child on the account. And what ends up happening is the child will use that account for whatever purpose that they want, maybe buying the Lamborghini.
Right.
And they that's not really what the parent intended to happen. And so that's one type of unintended consequence that's also kind of a loss of control feature with joint tenant accounts. There's also can be some income tax issues that go along with that, because if somebody, if two owners are on an investment account and there's a right of survivorship, they're joint owners. And so they're both going to get the 1099 interest forms, and that's going to be reported as income to them, whether or not they actually received the income or used it for their purpose. So those are pretty common problems that we see with the joint tenant with right of survivorship account.
Right, you better absolutely trust the other person that's on that account with you if you're gonna title it that way. So what about tenants in common?
So remember the thing about tenant in common that's different from joint tenant with right of survivorship is there's not the survivorship element to
Right.
it, right? You're just joint owning it in whatever percent your undivided interest is. So that retains a little control for you because you're in control of how it passes after death. It doesn't automatically pass to the survivor. The negative of that is it doesn't avoid probate, right?
Right.
Because once I retain the control about what happens after my death, then I've got to make some provision for it. If I do that through a will, it's through probate. If I don't do it at all, it's an intestacy situation, and it goes through probate. Also, with some tenant in common, problems that we see is if you and I own a piece of property together and I want it to go to you, right? We own it each 50%. And so what I do is when I die, I put in my will that you're going to inherit my 50% interest. Well, the problem is we talked before about step up in basis and what step up in basis is.
Oh, yeah.
Well, when you own something as tenant in common, your piece of the property doesn't enjoy a step up in basis, whereas my 50% ownership does.
Right.
And so you end up the sole owner of the property, but part of your interest is at the old basis amount and part of your interest is at the stepped up basis amount. That isn't of itself necessarily a problem, except it's really confusing. And so what we see is that at the end of the day, most people don't do the paperwork necessary to know what the right basis is. And so what we see often with tenant in common situations is that when you go to sell the property, you can't prove the step up of basis that you got on my half. And so you end up paying capital gains taxes on the entire piece of property, not just on your 50%.
Right. Right.
So that's a pretty common problem with tenant in common.
Yeah, the IRS loves that situation too.
They do. They
Yeah.
like that a lot
Yeah.
because they get paid twice on that one too.
So, do you have any examples, real life examples of joint tenants with rights of survivorship, let's say?
Yeah, so this is one that comes up all the time. There are a lot of problems that come up in the context of second marriages because, you know, we kind of have the his, hers, and theirs kids from different marriages. And so sometimes when I said that there's kind of the unintended consequence, sometimes the consequence, who you want to ultimately end up with your stuff, ends up not being the person that ultimately ends up with your stuff. So one example is we had a client named Bob, and he was married to Sue, and they had 2 children. So they had some accounts that Bob and Sue had generated together. They'd been married for a long period of time, had worked and had accumulated certain assets. And those assets were held in joint tenant with right of survivorship accounts. Okay, so Sue passed away. Now, who do you think that Sue would want to accede to that money, right? She wants Bob to accede to it because they're married.
Right.
She loves Bob. They earned it together. She wants Bob to get it. But if something were to happen to Bob, Sue probably wants her kids to get it or her grandkids to get it, right? That's kind of the natural course for Sue. Well, the problem is Bob kind of rocked along for a while. Kids grew up, kids got out of the house. Bob was a little lonely. Bob went on a cruise. Bob met a nice young lady, and they ended up getting married. Well, Bob thought the right thing to do when he got married to his second wife was to put her on the accounts, right? So they're married, they need to be on the bank accounts together, they need to be joint accounts. Now they were joint accounts with right of survivorship. Now remember, all of this money was money that basically was generated during Bob and Sue's marriage and that Sue would have wanted to go to her children. Well, when Bob passed away, guess who inherited all the money?
The new wife.
The new wife,
Yeah.
right. So that's a result that Sue would never intend. Well, it gets worse because that's this generation. What happens with the next generation? So Bob's second wife, when she passed away, guess who inherited the accounts? Her kids. Right. So do you think Sue ever intended for Bob's second wife's, well, essentially Bob's second marriage stepchildren to inherit the earnings that she had made and the investments that she'd made over the course of her lifetime? The answer is, of course, no. And that's what we see a lot of time with joint tenant with right of survivorship accounts is the way people hold joint tenant accounts, they don't think about what happens in the future, what could happen after they pass away, what happens one generation later. And so we see a lot of these accounts, especially in second marriage situations, that end up in a completely non-related person's hands, or even worse, in the non-related person's kids or grandkids' hands.
As a CFP, second marriage is a huge red flag. Just if people come in and it's their second marriage, just understand that's a huge red flag. So keep that in mind. Well, let's talk about beneficiary designations. This is one that's sort of near and dear to my heart, I guess you could say.
Yeah, the beneficiary designation, this is probably one of the most important things that you're going to do as a financial planner. You need to be all over your client's beneficiary designations. I mean, these are things that need to be tightened right, because beneficiary designations, one, they're typically named on all the type of financial accounts that you're going to deal with, from bank accounts to life insurance to retirement accounts to investment accounts. All of those typically are going to pass through the beneficiary designation. The beautiful thing about beneficiary designations is they are a contract between you as the account owner and the company. And so the company, after your death, is going to abide by their contractual obligations. And so once you present them a certified copy of a death certificate to show that the account holder has passed away, they're going to do the right thing by the contract, and they're going to cut a check or transfer the account to wherever the beneficiary tells them to. And so the great thing is it's a really quick and easy way to pass stuff. It's simple to set up. It avoids probate because it passes through the contract. And so beneficiary designations are a really good thing. There are some problems, though. The number one problem is that people are horrible about keeping their beneficiary designations current. Part of your job as being a CFP, as part of your job as being a financial planner or a broker, is to make sure that those beneficiary designations stay current. That's one of the best services that you can provide for your clients. Most of you are going to do annual reviews with your clients. And so when you do that annual review, it needs to be about more than just the investment portfolio. It needs to include what beneficiary designations do we have on file. Because I can tell you that what walks into my office from people who are sloppy with their beneficiary designations is lots of ex-wives and ex-husbands on beneficiary designations. Lots of dead people on beneficiary designations. Even worse than the ex-wives and the dead people are naming minors as beneficiaries on accounts.
Number one rule, don't do it.
Yeah, don't ever list a minor as a beneficiary on an account. It's a horrible mistake when you do that, and we can talk a little bit about why that is. Another problem that I see often on beneficiary designations is that it's not clear whether those distributions are supposed to be per stirpes or per capita. And I know we're going to talk about that in another section of the course about the difference between those two. But oftentimes that is very unclear. The The other problem I see with beneficiary designations, and why as a financial planner you should be all over this, is I see lots of people who bring in beneficiary designation forms that have never been signed and they've never been sent into the company. So what good is a beneficiary designation form if it sits in a desk drawer at your client's house? It doesn't do any good. That needs to be on file with the company. And so these are big issues that come with beneficiary designation. So, make sure that they're right, make sure that they get updated regularly, make it part of your annual review, make sure that the people are living and still married that are on those beneficiary designations, make sure that they effectuate the estate plan. If you've got a great, terrific trust plan and the beneficiary designation form goes to individuals, then that trust is unfunded, as part of that plan. So you don't want that. Make sure there's no minor beneficiaries on that form. I'll say it again. Make sure there are no minor beneficiaries on that form. If your client comes to you and says, I'm just going to put my kids down, the next question that you need to say is, how old are your kids?
Right.
Do you really want them getting the money, all of the money in one lump sum at that age? Because, it may be that they're not minors, but it may be that they're not as responsible as they could be. I've got a firmly held belief that no male's mind is fully formed until at least age 30. So if you
I was thinking more like 40.
Yeah. Well, the older I get, the number
the number keeps going up. That's right.
But I do think that, and so what you want to have happen in those instances is, even if you want to name the kid, you might want to name a trust for the benefit of the kid, as opposed to naming the child outright. So beneficiary designation forms, that is probably one of the best services that you can provide to your client.
Well, and the other thing too is, you got to keep in mind is, as a CFP, these beneficiary forms affect the estate. So if you're not 100% sure how they should be listed, first of all, know what their estate plan is. That's number one. And then second of all, if you're unsure, get back with their attorney and make sure that it's being listed the way it should be, because absolutely the wrong mistake here could end up costing you hundreds of thousands or more dollars. So just get it right.
And that's why you need to have a team approach to estate
Exactly.
planning. That's
Absolutely.
why the attorney and the financial planner and the insurance agents need to work together. And if you've got somebody that is not willing to work with you,
Get them off the
then
team.
That's exactly right.
Yeah. Find somebody else.
Find somebody else.